Is there any way we can get round this? And he said to me, Nev, I'm sorry, but I'm going to have to show him this because it's the only reason why we're having to settle. I've got to show him this. I said, Tom, I'm going to lose my job. He said, not necessarily, not necessarily. Could that be a true and accurate account of Neville Thirlbeck's recollection?
I have no idea of the conversation that Mr. Thirlbeck allegedly had with Mr. Crone around that. Mr. Watson, I'd be very happy to see that if you can provide it to us at another time. But I can tell you that at no point did Mr. Crone nor Mr. Myler discuss evidence or suspicion of wider spread phone hacking during the meeting of June 10th or otherwise in relation to increasing the offer of settlement with Mr. Taylor's attorneys.
I pressed him on this, Mr. Murdoch. He said, this is not some vague memory. I was absolutely on a knife edge. He was going to show this to James Murdoch. There's only going to be one conclusion he's going to jump to, which is get rid of Thirlbeck. Tom took it to him. The following week I said to him, did you show him the email? And he said, yes, I did. Now Tom can't remember if he showed it him now or spoke to him about it, but he said, yes, I did. I then said to Thirlbeck, so he did show it to him? And he said, yeah. No, this is Thirlbeck saying to me about what Crone said to him. He said, yes, it's all right. It's fine. We're settling.
Mr. Crone, I think, testified to you that he did not show me the email. My understanding is now that Mr. Crone, that the email was subject to some particularly stringent confidentiality agreement with Mr. Taylor's attorneys and the police or something like that. Mr. Myler was part of that confidentiality ring, I believe, but it was not shown to me at all. And I've only recently seen the email itself, which is as described. Here is the transcript for Neville, and then large blocks of redacted text of the actual things. And that's all I've seen, which is what you've seen. I saw it recently. It was not shown to me before. And I'm answering your questions in as clear and consistent a way as I can.
We published it in our report in 2010. You didn't look at it then?
Yes, I think I saw the words then at that point, yes. I think that
we published the email.
With the redacted, with the redactions, yes.
I would hope you might have looked at our report.
I did, as I testified earlier, I did look at the report. So, Mr. Watson, I really can't say what Mr. Crone and Mr. Thirlbeck may have discussed, and I'm happy to see that and deal with that. But my recollection is very clear, and all I can testify to you about is what I knew at the time, what I was told at the time, and what I was not told at the time.
You're familiar with the word mafia?
Yes, Mr. Watson?
Have you ever heard the term omerta, the mafia term they use for the code of silence?
I'm not an aficionado of such things.
Would you agree that it means a group of people who are bound together by secrecy, who together pursue their group's business objectives with no regard for the law, using intimidation, corruption, and general criminality? I'm not familiar with the term particularly. I've heard it vaguely. Would you agree with with me that this is an accurate description of News International in the UK?
Absolutely not. I think that's I frankly think that's offensive, and it's not true.
There are allegations of phone hacking, computer hacking, conspiring to pervert the course of justice, perjury facing this company, and all this happened without your knowledge.
As I've said to you, Mr. Watson, and to this committee on a number of occasions, it is a matter of great regret that things went wrong at the News of the World in 2006. The company didn't come to grips with those issues fast enough. I think we all recognize that. And I've also acknowledged that evidence to this committee was given without full possession of the facts in the past. And that's something that I'm very sorry for. What I can tell you, though, is that when evidence came to light and when we finally achieved the transparency that is appropriate, we have acted, and the company has acted, with great zeal and diligence to get to the bottom of issues, to improve the processes to make sure they don't happen again, and to make sure that our cooperation with the police, with this committee, and the like, are such that we can bring any wrongdoers, if they are proven to be so, to account.
Mr. Murdoch, you must be the first mafia boss in history who didn't know he was running a criminal enterprise.
Mr. Watson, please. I think that's inappropriate. Mr. Chairman.
Have you finished now? All right. Damien Collins.
Thank you, Mr. Chairman. I would like to ask you some questions, Mr. Murdoch, about the decision to settle the Taylor case, because you've rightly said that the meeting you had on the 10th of June 2008 was really about understanding what level of settlement should be paid. And in fact, Mr. Silverleaf is quite clear in his note. The brief he'd had from your company was not really should we settle or not, but how much should you be prepared to pay, and what are the tactics for concluding that settlement. So when was the decision taken? When did you take the decision that this case had to be settled?
I did not take the decision that it had to be settled. Mr. Crone and Mr. Myler had, previous to the meetings with me, already started to pursue that path, and I think that's become clear in the documents that have been provided to you by Mr. Pike after News International waived privilege on those things. And my understanding is that it was Mr. Crone who started the settlement discussions some weeks beforehand, and it didn't come to my attention until after it was necessary. They felt it necessary because the number had gotten large enough that it was going to draw my attention to it. But they had already sought to settle, or Mr. Crone had sought to settle at a variety of levels before.
Well, you said when you gave evidence to us in July, you said with regards to the settlement, you said that you were certainly not made aware of any new evidence. It was simply a matter related to the events that came to light in 2007 and in the criminal trials. Do you still stand by that statement?
That is what I was. That is what I understood at the time, and I was not made aware of new things in 2008. Yes.
Although you are saying now that you were aware of the transcripts, but were the transcripts were you aware the transcripts were new evidence? I mean, it was certainly all the internal discussion of them that we've seen suggests that it was regarded as new evidence.
I think it was a new. I think it was a new disclosure. I don't remember how exactly it was described as new or not. It was certainly presented as there is evidence. Here it is. They didn't show it to me, but they said it's a transcript of voicemail interceptions that have proved that it was on behalf of the News of the World, and that's what I was told.
It was clearly new information. It wasn't information that come out of the trials because this wasn't known.
Yes, but it was. I think, to be clear, it was an instance of voicemail interception that had already been part of the trials beforehand, i.e., that it was Mr. Taylor, his voicemail being intercepted. I think that was one of the counts that Mr. Mulcair was tried on.
But did you challenge them when you were having this conversation? Because the Taylor case was one that Farrers noted that they thought it was so weak the case ought to be struck out when it was filed in 2007, and yet less than a year later you were authorising it to be settled for up to £500,000. Did you question why this massive turnaround had taken place?
Well, the whole history of the case and the pleadings and whatever the Farrers or our own counsel had said about it was something that was predated my involvement in the company. It was brought to me as a case simply that would be lost. It was described briefly to me that there was evidence of the voicemail interception the transcript of the voicemail interception that proved that it was for or on behalf of the News of the World, that it was open and shut that the company would lose it, and that it was important to settle the case because litigating the case would be costly, and it was seen as a matter of the past, and it was seen more as the end of something that had been going on before, as opposed to the beginning of something new.
Were you told how much Michael Silverleaf had recommended the company settle at?
I was certainly told the number, and the number that sticks out in my mind, I think was I want to say 400 and something thousand pounds plus expenses and whatnot, and I believe that was ultimately the number that was settled on, and it may have been that was discussed.
Were you told what the number was in Silverleaf's opinion? I mean, he gives a clear view as to what he thinks the next step should be.
Yes, I think in his opinion, which I did not see at the time, was described as 250,000, possibly more, plus costs of both sides.
Yeah, he was recommending an increase from 150, which had been offered, to 250.
Yes.
By the time you met on the 10th of June, that had already been increased to 350.
Yes.
So was this described to you at all, the fact that these increases were being made and that you were being asked to sign off on a payment that was potentially double what the QC had recommended in his recommendation to the company?
No, the sort of the escalation of those offers and the back and forth is only something that's come to light to me recently, and it was described to me that an offer had been made. I can't remember the exact number of the offers that they talked about at the time, that it had been rejected, and that they thought, Mr. Crone and Mr. Myler, it would cost something in the range between 500,000 and £1 million, but that when you added up costs of both sides of litigating plus the damages recommended, that they thought that was reasonable, and they gave me very strong advice that it was commercially reasonable to settle.
So when you had this meeting on the 10th of June, this was the first you'd heard of all of this. You'd had there was no pre-briefing, you had no idea what they were coming to talk to you about. This is just...
Did you? The first I've heard of what?
Of the fact you were going to have to settle a case, the fact it was this amount of money. I mean, were you even aware of the Gordon Taylor case before this meeting?
Yes, it was certainly the only substantive discussion that happened, as we discussed at some length earlier. This question of the...
What does that mean, though, substantive? I mean, does that mean you had... What's non-substantive?
It's the only conversation that I recall. It went into some details about authorization to settle this thing and the evidence that was there. As we discussed earlier just a few minutes ago, there is this question of whether or not there was a conversation or a telephone call or something like that on the 27th of May. Neither Mr. Myler nor I recall it, but neither of us rule out the possibility that a brief heads up or a discussion in a hallway or a telephone call had happened.
In the note that Tom Crone prepared for Colin Myler, which we've discussed earlier, the Fore Neville email is only one of 3 issues that he cites with the case. The other 2 were the existence of the contract between News of the World and Glenmore Care for him to obtain information about Gordon Taylor, and also information that had come to the company as a result of from the police, which was information relating to the Information Commissioner's work, which suggested that there were examples of other journalists at both the News of the World and the Sun that were being involved in illegal activities. Now, this was given equal prominence, if not more prominence, by Tom Crone in his note. Was any mention of this made to you at all?
No, and I think it's important just to reiterate that the memorandum that Mr. Crone prepared was not shown to me or shared with me at any time during this period. I've since read it, and those things were not discussed. What was discussed was simply sufficient information to get authorization to increase the level of settlement, and that was what was discussed. None of those other things were discussed with me.
So you made your decision to increase to give them consent to negotiate up to £500,000 settlement with Gordon Taylor, simply on the basis that you were told the case will be lost, and you were told the reason it will be lost was because of the existence of this transcript. And those are the only reasons. And
that there was advice, when you added in costs of both sides, that made it reasonable to settle at a higher level. And I followed their advice to settle. I didn't decide to settle. They had strong advice to settle, and I consented with that advice of the senior legal manager for many, many years, and the editor of the News of the World, who I had no reason at the time to believe had anything other than the best interests of the company at heart, to say this is the advice to settle.
But I mean, had you have asked what the Silk's recommendation was, the Silk's advice you were waiting for, then you would know that they were asking to settle at a very high level, at a level at which it might be unreasonable to accept any court would ever award that amount of damages.
Well, I'm not sure that's the case. I think.
Certainly, what Mr. Silverley seems to suggest in his note.
But Mr. Collins, if you take the £250,000 or more, and you add in the costs both of Mr. Taylor as well as the costs of News International, were they to pursue that, you can get to higher numbers. So you have to add in both sides of those costs, which can be in the well over £100,000 or more on each side, depending on the complexity and so on. So I think there's from the standpoint of the amount that was agreed, they described to me that they had received counsel's opinion that this amount would be appropriate. They thought it was the right thing to settle. As they testified to you, they gave strong advice that it was the right thing to settle, and I followed that advice.
Just a final thing on that, in terms of the advice you get. Did you ever say to them, this is evident, this has already been part of a trial, that's what you understood, it's what you told us, why don't we just go to court? What's the risk? This case is already known about, there's only this small amount of new evidence, but the Mulcair link to Gordon Taylor is already known about. One of our journalists has already gone to prison for this. There's no one else involved, there's nothing new. Then what are the risks of going to court?
But if the company, and it was described to me that there was clear evidence that the company would lose the case, there didn't seem any point in taking it all the way to court and taking it on if the company was convinced it would lose the case and there was an amount of damages that were possible. And rather than go through that, it was reasonable to avoid that expense and distraction.
But did you discuss reputational risks to the company that might come out of a case like this?
I don't recall a particular discussion, although I think certainly it was seen as dragging up matters of the past, and it wasn't seen as it would have been desirable, not to have all of these things dragged up again. As I testified to you in July, I wasn't aware at the time that there was any confidentiality or anything out of the ordinary in terms of the confidentiality. But I think I wrote to you in August saying that confidentiality, in fact, was discussed between the different lawyers, and that was something that became clear to me